The next case on our calendar is Lykes Brothers versus American Heritage Life Insurance Company. Bobek?
Thank you, Your Honor. Barry Bobek for the appellant, Lykes. If I may, Mr. Marshall, reserve 5 minutes. May it please the court, thank you for hearing this case, and thank you for coming to Jacksonville. It made it a lot easier to be here. This case has a varying rationale. The insurer, American Heritage, started out as a rationale for back-charging interest after the policy had expired or been farted out, was first that you would not have been able to trade them for other policies. Secondly, that they would have lapsed without this oral agreement being made.
Is the oral agreement in dispute?
Oh, certainly, sir. Even Mr. Moorhead could only say that he understood, that he had the impression that there was an understanding. Did you shake on it? No.
At the trial judge found it wasn't.
Well, the trial judge adopted in whole the draft provided by the appellee, which has a lot of dicta. The real question is, how do you get to an oral agreement when you have written policies? How do we get to implied contract or equity when all of the conduct of the parties is regulated by the written terms of the policies? In this instance, it looked as though American Heritage was very upset about losing a sizable block of business, premiums, but also the 7% interest. Because remember, AHL is paying you on your money deposited in this investment vehicle 4%. But if you borrow it out, they're taking 7%. So there's a 3-point spread. So they found this novel idea arose to charge empty policies with interest. Gorgdahl, in a novel about Aaron Burr, relates a remark by Burr that a legal argument needs only to be plausible. And the plausibility of the argument now is that the statutes do not prohibit you from keeping a policy open and charging interest on it.
Well, if in November, instead of making the decision that Lykes did to cancel a number of the policies and keep only a few in effect, they had said, you know what, you're right, American, we like doing business with you, we're going to continue doing business with you. These interest charges that had accrued on the policies that had been canceled, they would have been paid and we would have continued on as they always have, correct?
Indeed.
So why then isn't it equitable for that period of time where that decision was being made for there to have been a cost incurred?
Well, because there's no cost provided for the policies. The policies say that you either pay, which Lykes didn't do, you surrender, redeem, reinstate, or abandon. They're individual policies, and so if you don't do anything, they should just become a nullity.
Unless the parties agree, as the trial court seemed to find, how we will conduct ourselves during this period where you're making a decision, right?
But they didn't need to agree. In fact, the whole premise of the case before the trial court has changed now before you. We didn't need to do anything, the appellee says now. Well, that was my point all along. There was no consideration for such an oral agreement because Lykes could have chosen to reinstate at any time. There had been no grace period commenced by giving the notice required by the statute. So they could have reinstated without medical examination or anything else. They could have caught up. Even if they were in the grace period commenced by notice, they would still have that right because lapse could not happen.
So you don't think that the insurance company could have, at some point during this negotiation period, said, you know what, we're going to accept the letter you sent us saying we want out of all these policies here. You don't think they could have done that?
I can speculate, Your Honor. I suppose they could have. They knew Mr. Harris, for instance, was suffering an illness. I'm not sure what motivated them.
Well, I guess my point is, if they could have, isn't that the consideration for that they exchanged for the price that you're being asked to pay?
I've never heard that argument before, Your Honor. Could they have treated the July tender as a surrender? Well, I suppose, but then we wouldn't have been back charged $336,000.
Would there have been a back charge if each policy was viewed as a standalone policy?
Well, that sum, Your Honor, is the individual policies. You may recall Helgeson, the AHL representative, was asked specifically, look, July 24th, it was $121.48 behind. Would you have collected that? No, Your Honor. Well, that,
Standalone policies?
right, well, various reasons, but no, Your Honor, we would not have. That's not our custom. Why then did you back charge the $1,800? Well, that was because they were used to fund a retirement program, as if the reason for purchasing a policy had something to do with how it's managed or how it's maintained. Again, they had the option to pay, surrender, redeem, reinstate, abandon. But what they said was you could not have redeemed the 25 or 28 without paying the back charge. You could not have moved that part of the book argument, A. B, that we continued to cover you during a period of time when we weren't receiving the premiums. A is false because those options are allowed to pay or redeem or surrender. B is false because it's always true. The insurers are not relieved until the grace period passes, and that has to commence with notice. What the argument is now turns the statutory scheme on its head. 627 provides protections for consumers. Subsection 4585 limits the policy loan interest. 458 allows the loans. Sole security should be the policy. In this instance, the sole security is not just the policy, it's treated by the trial court as a signature loan. Without a written note, although the policy terms say, if you want a loan, we will send you a note, no notes were produced.
But you agree that policies were overloaned?
They were borrowed out probably at the anniversary date, June 1st.
So if they were overloaned and Lykes surrenders the policies, is it your suggestion that they should not recover the overloaned amount? It should zero out?
Well, actually there couldn't be very much overloaned. $121 on Helgeson by July 24th. They actually they reduce the loan borrowability by the interest for the coming year. So at the end of the year, if it's not renewed, if it's not maintained, they have that sum and it's included, covered as part of the surrender charge. In this instance, the question to my mind is, what if nobody turned it in? Nobody surrendered it, nobody did anything. Sometimes we hear of people finding in the attic Ford motor stock that years and years is worth much more. The position the appellant takes here is that if that had happened and the policy was lost or misplaced, it could go unpaid, the premium advances and the 7% interest would continue to run until even the death benefit was consumed. Then an agent would be going to Mrs. Hutton, the widow, and saying, well, yes, ma'am, he did have insurance, but the estate owes us money, which I don't think is what insurance is about. I don't think that's the structure of the plan under the statute or under the policies.
Well, counsel, in your client's November 3rd, 1997 letter, I guess it is, after this period during which the parties agreed that the policies would remain in force, was there not a request in that letter for the loan payoff on all policies because there was an intent to pay off the loans completely, so please forward the total loan balance? What was the point of asking that?
Well, the point was we were keeping 28, and the number we got was for the loans on the 28, and the amount we paid was for the loans on the 28. It says all, but obviously the import was to maintain those policies that Lykes had elected to keep in force, and to forfeit the others. Thank you. Okay. Can I answer some questions for you?
Police Court. My name is Hunter Mallon, here with Jeff Eakin on behalf of the Athlete American Heritage Life Insurance Company, also AHL Brevity. I want to start off by addressing some of the points that Your Honors asked Cullen about, some answers that I thought misstated the either applicable law or the record, and I've taken them in reverse order. First, the claim that someone's going to go after a widow or an individual is incorrect. The owner of these policies was Lykes. Lykes was the one who paid the premiums, borrowed against the policies, received the money to fund their deferred compensation plan. Lykes was the one that owed any indebtedness on the policies as a result of filled up loan interest. It was not the individual, it was Lykes. Second, Mr. Bobek stated that these policies, or suggested that these policies somehow required the issuance of a loan agreement or promissory note. That's not correct. The policies themselves, for instance, page 9 of one of the forms of the policy states, the owner can borrow up to the available loan value of the policy. At the owner's request, the company, AHL, will send a loan agreement for signature.
As I understand this, Lykes is the owner of the policy and the beneficiary of the policy on the life of certain named employees or officers of the corporation.
That's correct, Your Honor.
And so Lykes borrows against the loan value.
Correct, Your Honor.
And some of those loans zero out.
Just a quick correction. They borrow against the fund value of the policy, and at some point, the fund value, there's no available fund value to borrow
There's no
against.
fund value. Okay. Then Lykes wants to cash in the number, however many policies they want to cash in. And my question was, so you take the value of policy A on one person's life and the value of policy B on another person's life. A has some value, B has no value, but you merge them in terms of the computation. They're not standalone policies. Is that?
That's correct. That's historically how these parties handled their book of business. As of 1997, they had 125 policies. We stipulated, both parties stipulated, that historically all the policies were billed, paid as a group. In fact,
Did the policies say that? Or were they standalone policies?
the policies do not state that they're group policies. They were put together as part of a group deferred compensation benefit plan that Lykes created. But if I could...
But they were the standalone policies on Mr. A, standalone policy on Mr. B, standalone policy on Mr. C, that you value them out collectively.
Correct. They are standalone policies. That doesn't change the fact that if indebtedness was created due to unpaid repayment of loans, due to the cost of insurance for the period of time that these policies were kept in force, that was still a debt owed by Lykes.
On C, the A and B may be treated differently?
some of the policies.
I don't want to take up all your time.
Right.
You go ahead.
Let me ask you this. On July 24th, when they sent the letter saying we're surrendering 100 to 125, if AHL had accepted that and said, okay, you don't want to do business with us, fine, would there have been any additional accrued interest charges that would have created a net fund value in any of the policies? Well, let me try a different way. Would you agree that had you accepted the surrender, you could not have had a negative fund value on any individual policy?
No, I disagree with that. As of July 24th, there were some policies that did have a negative fund value as a result of the accrual of loan interest and unpaid cost of insurance. It was smaller, significantly smaller as of July 24th as compared to November 3rd. And yes, AHL could have accepted the surrender request, just like Lykes could have sat on that surrender request when they were asked if they wanted to evaluate the tax consequences of it. However, by not sitting on that surrender request and not accepting it, Lykes also benefited by...
Let's step back to the point in time on July 24th. So your position is, despite the language in the policy, and despite the statute, which seems to limit the amount of security to the fund value, that surrender could have resulted in a negative fund value on certain policies?
Correct, because the security is different than indebtedness. We use the example of a home loan. You have a mortgage, which is your security. The value of your security may be less than what is actually owed. In today's times, we certainly see that situation a lot, where a homeowner, and oftentimes owes more than the value of their home. The homeowner still owes the indebtedness that accrues by the accrual of interest or unpaid principal on their loan, just like in this case, Lykes still owed. They benefited from loans that they took out on these policies.
Isn't the mortgage example somewhat of a false comparison, because the home is not the sole security. The home is the home plus you as the sole as the security for that loan. Here, as I understand this area of law, it's the sole security is that policy. It doesn't contemplate additional negative value, and the only reason, frankly, that I see you able to prevail here is because it was a post-July 24th agreement where the parties said, okay, we will not surrender, and in return, you'll keep our insurance in force. I mean, that's the only way that I think you can prevail here. I mean, how am I wrong?
Your Honor, I respectfully disagree. I think that when we see the word security in the statute, that does refer to security. I think the mortgage example is on point. A person is not security for an agreement. You can have an unsecured promissory note. The person is going to be responsible, just like in this case. Lykes is responsible for the accrued indebtedness, whether or not there's full security for it. If you have a promissory note and for partially secured, partially unsecured, some files bankruptcy, you have a secured claim only for the amount of the security, not for the unsecured portion. So in this case, once the fund value was zeroed out and loan interest continued to accrue, cost of insurance for maintaining the risk continued to accrue, you did have additional indebtedness owed regardless of the security. These policies also talk about what happens if the policy becomes overloaned. So it was perceived, envisioned, I should say, that these additional indebtedness could be created. I also don't read the statute as limiting the accrual of loan interest.
At what point could it stop accruing? I guess it's, if you have a $100,000 insurance policy, you're taking out loans against it, I guess conceivably under your analysis, that interest could accrue forever and be above $100,000. So when that insurance person dies, the insurance paid, the insured ends up owing money? Is that where you get to?
That's possible. I will say that in 1986, the tax code was changed so that what we're talking about now is not possible. You're not allowed to borrow up to the full fund value of the policy anymore. So in current times, that's not possible. But back then, for policies issued prior to the amendment in 1986, that was a possibility. And it could stop when the, for instance, if the surrender was accepted on July 24th, or if Lykes chose to surrender earlier than July 24th, earlier than November 3rd, or if AHL terminated the policies after proper notice for lack of payment.
Let's go to July 24th or thereabouts. They say, we want to surrender our policies. Your client says, no, wait. What was the agreement, what was the consideration that was exchanged that would support, assuming I'm right, that would support the additional approvals beyond that point? Well, what was the deal? Who gave what to whom?
Right. Initially, I would suggest that the policies themselves permitted the accrual of additional loan interest until they were surrendered. But the understanding that was reached was that AHL would maintain the 125 policies in force, provide coverage. Both parties agreed that if anyone passed away between July 24th and November 3rd, AHL would be on the hook for those death benefits. So AHL insured that risk for that entire period of time. And as we submitted at the lower court, it would be inequitable and I think improper if the lower court said November 3rd is your surrender date, as was the finding at summary judgment, that no one's challenged here. And if November 3rd is the surrender date, we then say AHL is not responsible or not able to collect compensation for carrying that risk through November 3rd. In fact, the Supreme Court in Kimball envisioned that and suggests that, you know, we don't intend for an insurance company to go uncompensated for the risk that they carry. This case actually presents facts that show that AHL carried that risk. If the policies were surrendered July 24th.
So, it essentially on August or July 24th, the deal was, in concept, in lieu of us accepting your surrender, we agreed to keep the policies in force, and you agreed to keep paying interest.
Pursuant to the terms of the insurance policies, correct.
But your argument is that's just what the status quo was in the contract.
That was the status quo, and as I submitted in the briefs, AHL loan interest cost of insurance would have continued to accrue at the rates under the insurance policy until they were terminated appropriately or until they were surrendered. And like
Okay, in that line of thought, that's because that policy was the sole security for that loan. Is that correct?
I'm sorry, I don't understand the
Okay,
connection.
each policy is a standalone policy. You can't, and so you've overloaned on certain policies, but that policy is the sole security for that loan. Policy A is not security for policy B loan.
Right, it's not security in the sense that you cannot, AHL cannot foreclose on another loan as a means of collecting on.
But you're moving money back from policy B to cover the loan in policy A.
Only of those policies actually surrendered, because there's no dispute that indebtedness was created as a result of, I think, 78 of the 97 surrendered policies. And I don't want to lose sight of the fact that there was evidence submitted that Lykes treated these policies as a group and not as individual policies either. Lykes borrowed against some of the pre-1986 policies to pay premiums on the newer policies. Lykes did not segregate funds that it had received from these policies by policy. It kept an account, it aggregated everything. Lykes paid each statement in mass. Lykes paid for the 28 policies it kept in mass and agreed at trial, Mr. Bobek agrees in his brief, that when AHL offset the $391,000 that was due on the 28 policies from the $480,000 net surrender value, that was proper, that it was okay for AHL to offset the $391 that was due on the 28 policies from the net surrender value on the 97 surrendered policies.
That was just a mathematical computation at that point, right?
Right, which is what I'm suggesting this whole thing was. When you take 90...
It all works out as a mathematical computation if you're right as a matter of law that you can have a negative value on any one given policy, right?
Correct, Your Honor.
Back to algebra, once you aggregate a bunch of negatives and a bunch of positives, you're going to get what you get.
Right, and that's really what our point is. The money was owed, whether we submitted 19 checks on the positive policies and sent them a bill for the other 78 policies, or whether we did it the way we did it to offset, the number's the same. It's our position that Lykes cannot have it both ways, that have the July surrender honored, Lykes would not have received death benefits on 3 of the Harris policies, which totaled $472,000. By waiting until November, they got the death benefits from the Harris policies without objection from AHL. AHL didn't say, oh wait, you surrendered these back then. I see my time has expired. We would ask that the court affirm the lower court's opinion.
May it please the court. Let me answer what I perceive to be a couple of questions. First, the charging the deficit, alleged deficit on policy A against policy B is justified throughout by this thing called block billing or list billing. There's no agreement, and one might expect in an operation of this magnitude that there would be a management agreement. There was none. And that process was never tested. There had never been a surrender. Secondly, finally, I'm glad to hear again the admission that they do stand alone. To answer your question, Judge Wetherell, if the July 24th surrender had been accepted, would there have been additional interest? Was there additional accumulations of interest? Counsel answered that the significantly smaller July amount was $300,000 smaller. And it's shown on the exhibit we used at trial, where the surrender value on July 24th would have been $1,166,000, but by November it was down to $845,000. It almost doesn't matter. If you allow negative value, you're going to lose $300,000 or more than $300,000.
Counsel, I need just a couple of basic questions answered from you real quick. Let's say Lykes Brothers had one insurance policy for $100,000. Lykes was permitted to borrow against that policy up to but no greater than $100,000?
Up to maybe 96 to reserve enough to pay the register and arrears.
Okay. So let's assume that Lykes has borrowed up to its limit, whatever that limit would be, decided that it wanted to surrender that policy. What is Lykes Brothers' obligation, financial obligation at that point? Does it just surrender it and walk away, assuming that interest has accrued on that loan over the amount of $100,000?
I think they can just walk away. I think they can amend it.
I think.
I mean,
does
my
under the
conclusions.
terms of the policy or under the whatever the relevant statutes would be.
Oh, yes, ma'am.
Lykes is permitted to walk away from that, to surrender the policy, even though the interest that has accrued on the amount borrowed now exceeds by however much the $100,000 value.
You can call it a surrender, an abandonment, what have you. Do they owe that interest? I have read those policies again and again and again. We lost a couple of witnesses. This is a no-2 case. I've almost memorized it. Nowhere is there a provision that in the event you're overborrowed, that excess interest will be paid. There's no shall accrue. There's no promissory there. The other interesting thing that may not be immediately noticeable is you couldn't borrow 96 for the first 7 years. So these policies all had built substantial fund value, and policy loans were not permitted until after that. So when they say, oh, well, there was a free ride, well, not really. On average, these policies were in effect 12 years, 10 or 12 years. And so there was substantial benefit to the insurance company to maintain them. There was no free ride because had a death occurred, the unpaid costs of the risk and interest and so forth would all been charged against the benefit. So I go back to the rationale given to the trial court, where the trial court asked, I'm going to ask you to assume that this is a policy that's not contained within a group of policies to fund a deferred benefit program. Let's say Mr. Helgeson is an individual on his own, has the exact same type of policy. Would be customary practice for AHL if Helgeson had terminated or surrendered his policy on July 24th to bill him for that accrued interest on the loan, outstanding loan, that accrued from June 1st to July 24th. Almost your question, huh? The witness, no, sir. And why is that? Because they were individual policies that we did not do an offset on those. It was different. It was not funding a deferred comp plan. Well, that's not from the policy. The policy doesn't say anything about the purpose for Lykes holding.
Counsel, thank you.
Thank you.